So the Corporate Transparency Act sounds like it's something just for corporations. In fact, the Corporate Transparency Act was targeted at small businesses. In fact, if you have a business that has more than 20 employees, more than $5 million in revenue, and has a presence in the United States, you don't have to qualify. You don't qualify. You're exempt from the Corporate Transparency Act. So the question is, if you are an estate planning attorney and you've got some business clients where maybe you've done an LLC for valuation discount planning or something of that nature, or just for basic business planning, and that LLC is owned by a trust, now you've got some issues where the trustee might be responsible for reporting on the beneficial ownership information. We created I'll just call it a decision tree that says, hey, trustee, here's some things to consider where you might have to be a reporting entity or a reporting party for the Corporate Transparency Act. When the Corporate Transparency Act came out, WealthCounsel put together a lot of materials for our members. In particular, we created a landing page on our website that has a lot of links out to references and materials that members could take advantage of. In particular, at the top of that, we put in the most recent updates because it continues to be an evolving area of the law where there have been some challenges to the Corporate Transparency Act. But we also put together some articles. We did a couple of webinars on the Corporate Transparency Act. And then for some of our members who subscribe to what we call Marketing Source, they got some additional marketing materials. We created a letter for all members, but in the Marketing Source materials, they also got some blog content and some other social media content for the Corporate Transparency Act. So when we had the Corporate Transparency Act come up, we got together, we looked at what the law was, we looked at what we would need to do, and in this case, we created about 20 different changes to our documents, and that was all very good. When we have any sort of a change like that, we get together, we do content review meetings, we do current development meetings regularly, and we decide what needs to be done in the products, but also in just like that landing page we did for the Corporate Transparency Act. So we're always trying to keep on top of these things. We monitor developments in the law. We then talk about them internally to determine what needs to be done in response. In some cases, there's no response, except to inform our members why this isn't an issue. And one of those cases was a revenue ruling called 2023-2, and that dealt with grantor trusts, where the Internal Revenue Service said grantor trust status alone is not enough to cause estate inclusion and to cause a basis adjustment. You need estate inclusion to get a basis adjustment. So we had a lot of members saying, gee, what are we doing now? Because all of our grantor trusts aren't going to work the way we thought they would. Well, no, nothing's changed. And so we just did an article on that, a little blurb that explaining why nothing has changed, and the documents you're preparing are still doing what they were designed to do.